dear viewers, wildlife forms a very integral part of environmental law. Hence, today we will be dealing with the wildlife protection laws. I will first deal with the introduction of the part of wildlife protection laws. The wildlife laws have a long history and are the result of an increasing awareness of ecological imbalances. The earliest codified law can be traced to 3rd century BC, when Ashoka, the king of Magadha, enacted a law to preserve wildlife and environment. But the first codified law in India, which heralded the era of laws for wildlife protection, was enacted in the year 1887 by the British and was titled as the Wild Birds Protection Act 1887. This act enabled the then government to frame rules prohibiting the possession or sale of any kind of specified wild birds which have been killed or taken during the breeding season. The British government in the year 1912 again passed the Wild Birds and Animals Protection Act 1912 as the Act of 1887 proved to be inadequate to protect birds and animals. The Act of 1912 was amended in the year 1935 by the Wild Birds and Animals Protection Amendment Act 1935. After the Second World War, the freedom struggle took precedence in India and wildlife was relegated to the background. But after independence, the Constituent Assembly in the draft constitution placed protection of wild birds and wild animals at entry number 20 in the state list, and the state legislature was given the power to legislate. Wildlife means the plants, animals and insects, etc., which are usually found in forests. In India, a long time back, an attempt was made to save wildlife by way of enacting Indian Forest Act 1927. It provided for hunting restrictions in protected and reserved forests. India is rich in its wildlife. According to Valmik Thapar in 1997, there are 13,000 species of flowering plants and 65,000 species of fauna, including fish, birds and mammals in India. In 1973, a centrally sponsored scheme, Project Tiger, was launched to ensure the maintenance of the population of tigers in India. In 1991 to 1992, the Project Elephant was launched, aiming at ensuring long-term survival of identified viable population of elephants and taking the problematic decrease of the elephant population. Let us now deal with international conventions and constitutional provisions relating to wildlife. In 1963, the World Conservation Union (IUCN) General Assembly passed a resolution calling for an international convention on regulations on export, transit and import of rare or threatened wildlife species, their skins and trophies. 10 years later, the dark end of the tunnel lighted up and 21 countries signed the Convention on International Trade in Endangered Species of Wild Fauna and Flora sites, the main aim being to check the over-exploitation through international trade. India is a party to 5 major international conventions relating to wildlife conservation, which are cited as Convention on International Trade in Endangered Species, Coalition Against Wildlife Trafficking, International Whaling Commission, United Nations Educational, Scientific and Cultural Organization, World Heritage Committee, and the Convention on Migratory Species. The Ministry of Environment and Forests is the nodal agency for these conventions. The Constitution of India under Article 48A has provided that the state shall endeavour to protect and improve the environment and to safeguard the forests and wildlife of the country. List 2 of the 7th schedule also empowers the states to make laws to protect, preserve and improve the livestock and prevent animal diseases and on fisheries. Dear viewers, we will deal with the salient features of Wildlife Protection Act 1972 now. In 1972, due to trade in skin of lizards, snakes, etc., that was sold in millions along with the tiger, rhino horns, bear paws and gallbladders, propelled India to enact the Wildlife Protection Act 1972. India became a party to CITES in 1976 by ratification. The salient features of the Act are mentioned as: the Act, according to the Act, hunting would include the capturing, killing, poisoning, injuring, snaring and trapping of any wild animal and includes an attempt to do so, or even injuring or destroying or taking any part of the body of such animal or bird or reptiles, or even damaging their eggs or disturbing their nests would also mean hunting. Trophy would include the whole or part of any captive wild animal other than vermin preserved by natural or artificial means and includes rugs, skins and specimens of such animals mounted in whole or part by taxidermy. Antlers, horn, hair, feathers, nails, tooth, musk, eggs and the next would also be called a trophy. Specified plants refer to the plants specified under Schedule 6. The Chief Wildlife Warden may grant a permit to hunt any wild animal for the purpose of education, scientific research and management, collection of species for zoos, museums and similar institutions, collection and preparation of snake venom for the manufacture of drugs. It is prohibited to pick, uproot, damage or collect willfully any specified plants under Schedule 6 from any forest or any area specified by a notification of the central government. The possession, sale or even offer to sell specified plants dead or alive or their derivatives is also prohibited. Sanctuaries, national parks and closed areas are very important under the wildlife protection laws. The state government, if it considers an area of adequate ecological, floral, faunal, natural or zoological significance for the purpose of protecting the developing wildlife, may declare such area other than a reserve forest to be a sanctuary. It shall have restricted entry. Entry without weapons is prohibited without previous permission of the wildlife warden in this zone. It is the duty of the wildlife warden to immunize livestock within 5 kilometers of the sanctuary against all communicable diseases. Zoos. The Central Zoo Authority specifies the minimum standards of housing, upkeep and veterinary care of animals and accessing the functioning of zoos, maintaining registers and coordinate acquisition, exchange and loan animals for breeding purposes, etc. The central government shall constitute the Central Zoo Authority consisting of a chairperson, team members and a member secretary. They shall hold office for a period of 3 years. The Central Zoo Authority shall perform the following functions: specify the minimum standards for housing and veterinary care of the animals kept in a zoo, evaluate and assess the functioning of zoos with respect to the standards or the norms as may be prescribed, recognize or de-recognize zoos, identify endangered species of wild animals for purposes of captive breeding and assigning responsibility in this regard to a zoo, coordinate the acquisition, exchange and loaning of animals for breeding purposes. Wild animals and animal articles. Wild animals are basically the property of the government. In case of any person obtaining possession of such animal or article, he may report it to the nearest police officer within 48 hours or hand over such property to the officer in charge. Certificate of ownership may be granted by the Chief Wildlife Warden in case of legal possession of animals or their parts or articles which he may mark in a prescribed form for the purpose of identification. Trade or commerce in trophies, animal articles, etc. in Schedule 1, Part 2 of Schedule 2 are prohibited by law. This includes the manufacture, import of ivory, taxidermy and dealing with trophy, captive animals or their meat. Let us deal with an important part: prevention, detection and penalties under the Act. The Director or any other officer authorized by him or any Chief Wildlife Warden may on reasonable suspicion require inspection of any captive animal. Wild animal, meat, trophy, cured or uncured, specified plants or part thereof or license or their permits. He may also stop any vehicle to search or inquire or enter land and such premises, land, vehicle, vessel or other possessions. The tools, traps, vehicles, vessels or weapons used for the commission of the crime may be forfeited in addition to any other punishment. Section 9 of the Act prohibits hunting of any wild animal specified in Schedules 1, 2, 3 and 4. Any person who hunts any wild animal shall be punishable with imprisonment for a term which may extend to 3 years or with fine which may extend to rupees 25,000 or with both. However, if any person commits the offence in the sanctuary or national park with respect any animal specified in Schedule 1, he shall be punishable with imprisonment which shall not be less than 1 year but may extend to 6 years and also with fine which shall not be less than 5,000. Offences committed with respect to Schedule 1, Part 2 of Schedule 2. Possession of meat of such animal or article in relation to hunting in a national park or sanctuary shall be punished with imprisonment for 6 months, extending up to 6 years or a fine not less than rupees 500. Subsequently, offenders attract a minimum imprisonment of 2 years and fine not less than rupees 10,000. As per Chapter 5th A, offences in relation to trade or commerce in trophies or animal articles from Schedule 1 or Part 2 of Schedule 2 shall be punished with imprisonment not less than 3 years, which may be extending up to 7 years, and also a fine not less than rupees 10,000. Under Section 38J, teasing an animal in the zoo shall be punishable with imprisonment extending up to 6 months or a fine not less than rupees 2,000 or both. Subsequent offenders attract imprisonment up to 1 year and fine extending to rupees 5,000. Licenses under the Arms Act 1959 being cancelled shall not be granted for a period of 5 years from the date of conviction. The procedure of courts and cognizance under the Act. Courts have only been empowered to take cognizance of cases against the Act on complaint of the Director of Wildlife Preservation or any other officer authorized by the central government or the Chief Wildlife Warden or any other officer authorized in this behalf by the state government, any person giving notice of not less than 60 days in the manner prescribed of the offence and of his intention to make a complaint to the central government or state government or the authorized officer. Let us now deal with the duties of Wildlife Advisory Board under section 8. The Wildlife Advisory Board mainly constituted to advise the state government in the following matters: in the selection of areas to be declared as sanctuaries, national parks and closed areas and the administration thereof, in formulation of the policy of protection and conservation of wildlife and specified plans, in any matter relating to the amendment of any schedule, in relation to the measure to be taken for harmonizing the needs of the tribals and other dwellers of the forests with the protection and conservation of wildlife. There were some amendments made to the Act. An amendment to the Act in 1982 was introduced by provisions permitting the capture and transportation of wild animals for the scientific management of animal population. An amendment in the year 1991 resulted in the insertion of the special chapters dealing with the protection of specified plants and the regulation of zoos. This also recognized the needs of tribal and forest dwellers, and changes were introduced to advance their welfare. Widespread changes have been made by the Wildlife Protection Amendment Act 2002, and a new chapter has been incorporated as Chapter 6A to deal with the forfeiture of property derived from illegal hunting and trade. Further, this Amendment Act also introduced the concept of cooperative management through Conservation Reserve Management Committee and Community Reserve Committees. By the 1991 amendment, specified plants were brought under the protective umbrella of the Act. The amendments also envisaged establishment of a central zoo authority to regulate the management and functioning of zoos. The boundaries of sanctuaries and national parks may not be altered except by a resolution of the state legislature. The Act regulates trade and commerce in wild animals, animal articles, trophies and derivatives from certain animals. Any violations of the provisions in the Act attracts imprisonment and fines. The Wildlife Protection Amendment Act 2002 provides for establishment within 3 months of a national board for wildlife to be headed by the Prime Minister and manned by the Minister for Environment and Forests and 25 other members to oversee protection of ecological balance in the country. At the state level, a similar body to be headed by the Chief Ministers constituted. The Amendment Act also envisaged a non-bailable offence for violation of this Act, besides providing for forfeiture of property derived from illegal hunting and trade, prohibition of holding illegally acquired wildlife property, assistance to the administrator by police, state forest departments, Central Economic Intelligence Bureau, Directorate of Revenue Intelligence and other such officials. It also provides for a deterrent punishment with imprisonment for a term extendable to 5 years and with a fine of rupees 5,000 for acquiring property in violation of the amended Act. The protected area network in India includes 99 national parks and 513 wildlife sanctuaries, 41 conservation reserves and 4 community reserves. The Animal Welfare Division became a part of Ministry of Environment and Forests in July 2002. Earlier, the division was under Ministry of Statistics and Program Implementation. The mandate of Animal Welfare Division is to prevent the unnecessary pain or suffering caused to animals. The main task of the division is to implement effectively the various provisions of the Prevention of Cruelty to Animals Act 1960. The division provides assistance for construction of shelter, houses, dispensaries for stray, infirm and abandoned animals. The Wildlife Protection Act 1972 was amended in 2006 to incorporate the creation of the National Tiger Conservation Authority. With the amendment of this Act, a Wildlife Crime Control Bureau was also subsequently established. In May 2006, the Government of India initiated preventive actions to curb further decline in the population of vultures, which also includes banning the use of diclofenac in veterinary sector. The Wildlife Protection Amendment Bill 2013 introduced in the Rajya Sabha seeks to ban the use of animal traps except under certain conditions, engage Gram Sabhas and Gram Panchayats in management of protected areas, and to grant hunting rights to scheduled tribes of the Andaman and Nicobar Islands. The bill proposes that hunting in national parks and sanctuaries or the alteration of their boundaries should be punished with 5 to 7 years in jail and fine of rupees 5 to 25 lakhs, up from 3 to 7 years in jail and rupees 10,000 fine in the current law. The punishment would be 7 years in prison and rupees 30 lakh fine for repeat offenders, up from 3 to 7 years of imprisonment and rupees 25,000 fine. The amendments propose stricter deterrence for crimes related to sale, purchase and transfer of animals, their parts or products listed in various schedules. The Central Zoo Authority was reconstituted for the 6th time in September 2007 with Minister of State, Environment and Forests as its chairman. There has been tremendous judicial activism in the area of wildlife protection. Let us deal with some important cases in this area. Jaladhar Chakma versus Deputy Commissioner Aizwal, Mizoram. In this case, the villagers were evicted from the area falling within the sanctuary. They approached the court stating that the respondents did not follow any of the provisions of Chapter 4 of the Wildlife Protection Act 1972. The Development Commissioner, who is ex officio secretary to government, declared the sanctuary under Section 18 of Wildlife Protection Act 1972. The court held that the orders of eviction of villagers from area falling within declared sanctuary was based on purported declaration, hence not sustainable, and allowed the petition. The court further opined that the respondents have not followed any of the provisions of Chapter 4 of the Act. Velor Coelho, deceased and others versus State of Tamil Nadu. In this case, the petitioners challenged the Wildlife Protection Act 1972 and the Wildlife Protection State of Tamil Nadu Rules 1975 on the following grounds. There is violation of Article 14 of Constitution of India. There is violation of Article 19, Class 1, Class G of the Constitution of India. There is lack of legislative competence. There is excessive delegation under Section 61 of Wildlife Protection Act 1972 and approach the High Court of Tamil Nadu. Relying on judgments of the Supreme Court, the High Court rejected the contention that the right to hunt a wild animal, even when it proves dangerous to property, is an integral part of the fundamental right to hold property or partakes of the same basic nature and character as that of a fundamental right, and dismissed the writs. Another case is of Tarun Bharat Singh Alwar versus Union of India and others. In this case, Tarun Bharat Singh Alwar brought a public interest litigation for enforcement of statutory notifications promulgated under wildlife protection and forest conservation laws in Sariska Tiger Park, declared as reserve forest in the state of Rajasthan, against illegal and arbitrary issuing of 400 mining privileges to various persons, enabling them to carry on mining operations of lime and dolomite stones inside areas notified as Sanctuary, National Park, Project Tiger Area, Sariska and Reserved and Protected Forest. In order to protect the environment and wildlife within the protected area, the Supreme Court issued directions that no mining operation of whatever nature shall be carried on within the protected area. Another case is of Animal and Environment Legal Defence Fund versus Union of India. In this case, the petitioners, an association of lawyers and other persons concerned with the protection of environment, filed a public interest litigation challenging the order of the Chief Wildlife Warden, Forest Department, granting 305 fishing permits to the tribals formerly residing within the national park for fishing. The Supreme Court protected the right to livelihood of the tribal villagers and at the same time showed its concern for the protection of the environment. The Supreme Court also observed that it could have been more desirable had the tribals been provided with suitable fishing areas outside the national park or land that has been given for cultivation. Coming to the conclusion of the chapter, regardless of an individual's opinion, the community has an increasing expectation that animals be treated in a human manner. This expectation is translated into animal welfare laws, which place both legal and moral responsibility on all those who own, manage or interact with animals to ensure their welfare. Recently, the Cincinnati zoo officials killed an endangered silverback gorilla, Harambe, to safeguard a 3-year-old boy who somehow entered into the prohibited zone and reached near the gorilla. This killing spurred a debate on the issue of animal rights and protection. It was negligence on part of parents which led to such situation. But still, are we living in such a world where animals are considered to be inferior to human beings? This is a question to be answered by us, as we are all part of the nature and we don't have the right to discriminate, as rightly said by Albert Schweitzer. We must fight against the spirit of unconscious cruelty with which we treat the animals. Animals suffer as much as we do. True humanity does not allow us to impose such sufferings on them. It is our duty to make the whole world recognize it. Until we extend our circle of compassion to all living things, humanity will not find peace. Dear viewers, I hope the session on wildlife protection laws would have been informative to you. Next session will be dealing with the sustainable development and environmental areas All the aspects of sustainable development will be dealt in the next chapter. Thank you and have a great day ahead.